All rise. Hear ye, hear ye, hear ye. The Court of Appeals of the State of Michigan is now in session. The Honorable Annika Ledick, the Honorable Randy J. Wallace, and presiding the Honorable Michael J. Kelly. All persons having business herein draw near, give attention and shall be heard. God save the United States, the state of Michigan, and His honorable court. Please be seated.
Well, good morning. On behalf of three of us, Judge Ledica and Judge Wallace, welcome on this snowy day. I think all of you have crossed swords in here before, so we'll just get started right away here. I should say that if, and this is for some of the later cases, if your case involves a minor child, please refer to them by their initials and not their names. First case today, item 1 is actually consolidation of 8 cases. And I'm also required to have to read off the docket numbers. So let me start with that. Item number 1, 36, it's in-ray application of Enbridge Energy to replace and relocate line 5. They are docket numbers 369156, 369157, 369159, 369161, 369162, 369163, 369165, and last but not least, 369231. Have you worked out who's arguing? You know, each side gets a half hour. All right, so with that, let's begin.
Good morning and may it please the court. My name is Adam Rachensky with Earth Justice, arguing on behalf of the tribal intervenor appellants, the Bay Mills Indian Community, the Grand Traverse Band of Ottawa and Chippewa Indians, the Little Traverse Bay Band of Odawa Indians, and the Nottawasepi Huron Band of the Potawatomi. Just to give an overview of appellant's presentation, I will argue for about 12 minutes, followed by Mr. Gonzato for about 8 minutes, and then by Ms. Lesueur, who will cover public trust and MIPA issues for about 5 minutes. We would like to reserve 5 minutes for rebuttal. The proposed Line 5 tunnel project threatens natural, cultural, and economic resources in the Straits of Mackinac and throughout Michigan that are vitally important to the tribal intervenors. Line 5 crosses over 290 rivers and streams, many of which the tribal nations have treaty rights to fish and which are interconnected with each other and the Great Lakes. They join this proceeding to protect these critical resources. At the beginning of this contested case, before the parties had the opportunity to conduct discovery and submit evidence, Enbridge filed a sweeping motion in limine to exclude 6 categories of evidence and issues from the proceeding. The motion was a subject of extensive briefing and argument, and the commission's errors began with its April 21st, 2021 order on the motion in limine, which it granted in part and denied in part. The commission erred by barring intervenors from submitting evidence and conducting discovery on both the question of the public need for the petroleum products transported through Line 5 and the full scope of environmental impacts, namely the risk and pollution from oil spills that flow from this project's approval. The tribal appellants have identified 2 independent reasons why reversal and remand to the Public Service Commission is appropriate in this matter. First, the commission violated intervenors' rights under the Michigan Administrative Procedures Act and violated the Michigan Rules of Evidence by barring intervening parties from introducing evidence related to the public need for the products shipped through this replacement project and then making explicit findings adverse to intervenors on those same issues in its December 2023 order. Second, the commission's final order was unlawful and an abuse of its discretion because it violated the Michigan Environmental Protection Act by barring intervenors from conducting discovery and submitting evidence about a critical environmental effect of the conduct at issue in this administrative licensing proceeding, the risk of oil spill that flows throughout Michigan and will continue for 99 years as a result of the commission's approval of the permit in this matter. Turning first to the public need, in its final order, the commission made factual findings on exactly the set of issues it ruled were outside the scope of the case. Holding at page 305 of its December 2023 order, quote, Enbridge has established both the public need for the products to be shipped through the replacement project and the need to relocate the Straits Line 5 segment in the tunnel and as such has established the public need for the replacement project. The commission relied upon record evidence in reaching this conclusion, and that evidence went directly to the public need to preserve and extend the pipeline's continued operation, which is the precise topic the commission barred intervening parties from submitting evidence on. And the commission went further, making the explicit finding that there's an ongoing reliance on the current capacity of the pipeline, that if Line 5 in Michigan may be abandoned in full or in part, it will require higher risk and costlier fuel supplies and transportation to Michigan customers. This is a straightforward violation of the Administrative Procedures Act, which demands that intervening parties be given an opportunity to present oral and written evidence on issues of law and an opportunity to present evidence and argument on issues of fact. It further provides the parties a right to submit rebuttal evidence. And this violation of interveners' rights was not a harmless error. The right to present witnesses, evidence, and argument, and to present rebuttal evidence is part of the rudimentary due process that's required in administrative proceedings. In a sense, it's not surprising the commission ultimately made these explicit findings on this topic when Enbridge put the issue front and center in its application, which set the stage for this contested case. For example, you can see Tribal Appendix F at 640, where Enbridge witness Marlon Samuel, whose testimony was submitted along with the application, testified to the continued expected demand for the products shipped through this replacement project, how it will continue well into the future, and how there's a lack of sufficient capacity on other pipelines to serve these markets and transport these types of products. Later on, you can see Tribal Appendix M, which is the application in this matter. Enbridge claims that Line 5 provides needed energy transportation and further states that the products will continue to be refined to meet the needs of Michigan. And as a result, under the APA, the parties had a right to submit evidence to rebut that evidence that came into the record along with Enbridge's application. The commission violated interveners' substantial rights under the APA when it barred them from doing so. And moreover, due to its own error, the commission was left with an incomplete record, a record that contained factual evidence supporting its finding for a public need for the products shipped through the replacement project, but not evidence to the contrary because interveners were barred from developing and submitting it. And not only did this run afoul of the tribal interveners' rights under the APA, but it also violated the Michigan rules of evidence. This evidence was relevant under 401, admissible under 402, and its exclusion violated a substantial right of the parties, which is grounds for reversal under MRE 103A2. Moving on to MIPA. Although the commission correctly held that greenhouse gas emissions must be considered under MIPA, recognizing that it defies both well-accepted principles of statutory interpretation as well as common sense to apply MIPA to a pipeline but not products being transported through it, the commission abused its discretion and violated MIPA when it prevented intervening parties from submitting evidence about the risks of and likely pollution from oil spills from Line 5 in Michigan that flow from this project's approval. The plain language of MIPA and the Supreme Court's holding in Vanderklut require that the commission, in an administrative licensing proceeding such as this, undertake a broad assessment of the likely effects of a project to determine whether and to what extent it will cause impairment of Michigan's natural resources. The phrase likely to have such an effect in the plain text of MIPA demands a comprehensive consideration of the effects of the conduct at issue. And as set forth in our briefing, effect means something produced by an agent or cause, a result or an outcome or consequence. And it's apparent for several reasons that the conduct at issue in this licensing proceeding is to secure the operation of a pipeline that may otherwise cease to operate, and at the very least, extend that operation for additional decades that would not occur in absence of this permit. First, the segment to be replaced has had its easement revoked by the governor and the Department of Natural Resources for numerous violations of the easement's terms, including a failure to uphold the basic standard of due care. Second, it's subject to a separate lawsuit by the Attorney General Dana Nessel, which will be argued less than 2 weeks today, seeking to shut the pipeline down, segment to be replaced, on public trust and MIPA grounds. And that case is already seen an order from the court shutting the pipeline down before. It could happen again in mere months. And finally, even setting aside those state actions dealing with the segment to be replaced, it's not reasonable to conclude that Enbridge will be able or permitted to operate this segment to be replaced, which has grave safety concerns and has been the subject of state actions indefinitely. In light of these critical facts, it becomes apparent that the project would, at minimum, extend the operation of a pipeline that would otherwise cease to operate and extend the operation of Line 5 in Michigan. As a result, the environmental impairments on Michigan resources due to likely oil spills that flow from extending Line 5's operation must be considered here. And these are likely impairments of this project. Line 5 has spilled 1.1 million gallons since it was constructed, and it's likely it will continue to spill into the future. Likely pollution from oil spills is an effect of the conduct at issue in this licensing proceeding, and a consideration of this type of causation effects is aligned with MIPA case law. In West Michigan Environmental Action Council versus the Natural Resource Commission, the Supreme Court considered the impact of road construction on the wildlife population in the Pigeon River State Forest, even though the action properly before the circuit court was a permit for exploratory wells, because without the permit for those wells, those roads would likely not be built. And here too, the oil spills and the resulting impairment that flow from Line 5 in Michigan would likely not occur in absence of this project's approval. And finally, the Commission's alternatives analysis failed to comply with MIPA because it considered oil spill risks from alternatives all along their length, but not those associated with the project itself. For example, when discussing a southern pipeline route that's an alternative route, the Commission looked at exactly the type of evidence the tribal interveners wanted to submit about Line 5's operation and the threat of impairment it poses to Michigan resources. Looking at the number of river crossings, its proximity to the Great Lakes, how many wetlands it traverses, its proximity to community drinking well sources. But interveners were not allowed to present similar evidence about Line 5's proximity to these natural features, the number of water crossings, or the integrity of this pipeline that may actually increase the impairment of these and other natural resources when compared to the alternative pipeline routes. Instead of doing this sort of apples to apples comparison, the Commission compared the oil spill risk from a 4-mile new pipeline segment in a tunnel with that from a 762-mile alternate route. And this comparison was just unreasonable. It was incongruent, and it led to an improper finding under MIPA. If you're looking at how to transport oil from Superior, Wisconsin to Sarnia, Ontario, it makes sense to do it along the whole length, which they did for the alternative southern pipeline route. But then when they compared it to actual Line 5, they looked at a tiny segment that was a new pipeline in a tunnel. And this was just incongruent and arbitrary under MIPA. For those reasons, Your Honor, the tribal interveners respectfully request that this court overturn the decision of the Public Service Commission and remand it with instructions to allow intervening parties to submit evidence about the public need for the products shipped through the replacement segment and evidence on the likely pollution from oil spills in Michigan that flows from this project's approval and will perpetuate the operation of Line 5 in Michigan. Thank you.
Any questions? No. Okay, thank you very much. Next is Mr. Gonzalo.
Good morning. I'm Mark Gonzago on behalf of the two of the interveners in this case, Environmental Law and Policy Center and the Michigan Climate Action Network. I must tell you at the beginning, I am still recovering from surgery, which has in fact affected my speech. If there's anything I say during the course of my limited remarks, I'm assigned 8 minutes here, so it's not very long. Anything you don't understand, I won't be offended if you ask me to repeat.
So far, so good. I'm glad to hear you're recovering.
Thank you. Thank you. My two clients' major interest and expertise is in the area of climate change. And therefore, their interest in this case came down to greenhouse gases. And that's where I'm going to confine my remarks here to the time I have here. As you just heard, there was a motion in limine that Enbridge filed, and that motion in limine did in fact seek to exclude from any of the contested case proceeding evidence with respect to climate change and greenhouse gases. The key decision in this case from my client's perspective is the April 21, 2021 order addressing that motion in limine, because in the course of that order, the commission made two critical findings of import to my clients. The first one was whether they could look at the purpose and the products flowing through the pipeline. And whether they had the authority to do so. They found that under Act 16, the statute that provides the commission with its power over pipelines, they did in fact have that. And the commission further concluded that they had the authority and the obligation under MCOA to also examine those the products. And the quote that's important for me to stress in that respect can be found on page 64 of the court's opinion, of the commission's opinion. It defies both well-accepted principles of statutory interpretation as well as common sense to apply MCOA to a pipeline, but not to the products being transported through it. So the commission began, before it even started taking evidence, with the assumption that it would be looking at, through the lens of MCOA, at the actual products flowing through this pipeline. They made a second critical conclusion from my client's perspective, only 2 pages later in their decision on the motion in limine, and that is they examined MCOA itself and the concept of pollution, and they made a second critical finding, and that is that greenhouse gases do in fact constitute pollution for purposes of MCOA. What the commission did at that point, once they made these two critical findings, first that they could look at the products flowing through the pipeline, and that greenhouse gases do in fact constitute pollution for purposes of MCOA. They said, thus the parties are free to introduce evidence addressing the issue of greenhouse gas emissions and any pollution, impairment, or destruction arising from the activity proposed in the application. So the commission at an early stage in this process asked for evidence on greenhouse gases, and my clients gave it to them. They took the commission at their word, and what my clients did was present the evidence of 3 highly qualified experts. In my limited time here, I can't go into any details about what that testimony was. But in general, what they first established is the danger presented by climate change to Michigan's natural resources. These 3 experts that the plaintiffs call also quantified the cost, the carbon cost that comes from greenhouse gases, and the greenhouse gases that not only would be produced by the project itself, but by the products flowing through the pipeline. So the plaintiff, my client, presented this evidence. And basically, what happened is that the commission, in essence, disregarded all of this testimony. What the commission did instead, despite the evidence, and this was a very important part of the expert testimony, that there was long-term reduction in greenhouse gases if the commission turned down this request. A long-term reduction, and really not contested in this case during the evidentiary phase. And what the commission did, despite that testimony, is they basically assumed all of that testimony away, because in their final order from December 1 of 2023, the commission said, we find that a shutdown would actually result in a significant increase. Now that was directly contrary to the testimony that my clients provided, but it would increase greenhouse gas emissions at least in the short term. That's what the commission did then was to disregard the testimony that my clients presented with respect to the long-term impact of this, and basically assume that the end result in terms of greenhouse gases from this project was going to be a wash. In fact, they suggested that at least in the short term, it would be greater, the emission of greenhouse gases. But the point is, the commission asked for expert testimony. They asked for expert testimony on the question of greenhouse gas emissions, and they got it. And after getting it, they ignored it and confined themselves to this question of whether in the short term, well, this is a project that's going to last at least as Enbridge projected, 99 years. It's going to create billions and billions of barrels of oil that are going to be coming through the Straits of Mackinac if this project is in fact ultimately approved. The fact is that the short term was basically meaningless in the context of this case. So I know my time is limited here. We've also indicated that there was, in fact, a mistake made by the commission with respect to the burden of proof and how that should operate. Now, Enbridge has challenged that, suggesting that it does not apply in the administrative setting. I think that in rereading the Vanderklut case, that position is incorrect. That in point of fact, that the burden of proof rested with us, just to show that there was going to be pollution. That was a given once the commission made their original finding with respect to greenhouse gases constituting pollution. And then the burden had to shift to Enbridge to, in fact, justify it under the MCOA standards. I'm almost out of time. I don't, if any questions.
No questions. Thank you.
Thank you.
Morning, Your Honors. May it please the court, my name is Carrie Lasser, representing For Love of Water, based in Traverse City, one of the communities that would be devastated within hours by a Line 5 pipeline breach. We're allocated 5 minutes for argument and reserve 1 minute for rebuttal. Flow endorses the preceding appellant's arguments and relies on its briefing regarding public need and violations of the Michigan Environmental Protection Act. I focus my remarks on the broad applicability of mandatory determinations required by Section 1705(2) of MCOA. Under 1705, the Commission determined that the conduct, the tunnel construction, and the transport of 23 million gallons a day of fossil fuels for 99 years will or is likely to pollute and impair the air, water, natural resources, and public trust in the Straits of Mackinac. And that's at pages 329 to 332 of the December 1st, 2023 order. Under the plain direction of 1705(2), as determined by the Commission, the tunnel project could not be approved unless it is shown and determined that there are no feasible and prudent alternatives to the conduct, that is, the tunnel. Appellants have expert evidence that the pipeline's costs are skyrocketing. The no-action alternative is likely not continued operation of the dual pipelines in the Straits, and alternative routing would create both lower spill risk and lower financial risk for Enbridge, investors, and consumers alike. We ask for the opportunity upon remand to present this evidence to the Commission. The Commission failed to evaluate alternatives outside the 3 alternatives in the Straits: the tunnel, boring and pipe, and the existing line. That's not what MCOA requires. A full evaluation of alternatives was essential to MCOA compliance. The commission should have allowed the parties to submit full and comprehensive evidence on whether there were feasible and prudent alternatives outside the straits, such as unused capacity on Enbridge's Southern Michigan pipeline and others in the grid, and rebut Enbridge's assertions about the no-action alternative. For these reasons, 17052 has been violated. The permit should not have been approved for lack of a proper determination or finding based on a comprehensive record on the no alternative requirement. In effect, by limiting its review to the replacement segment alone, the commission fell for Enbridge's red herring argument that the no action alternative means continued operation of the dual pipelines. In fact, there is widespread active opposition right up to the governor's office. Line 5 has spilled over 1 million gallons of oil in its 72 years. More likely no action alternatives include use of capacity over other overland routes without pollution or harm to the Great Lakes and Straits of Mackinac, and increased reduction in demand for natural gas and crude oil. The PSC chose an inaccurate framing of alternatives, constituting reversible error. With regard to the limitations of Act 16 review, we note that MEPA Section 1706 explicitly provides that it is supplementary to existing administrative and regulatory procedures provided by law. MEPA therefore extends beyond the limits of Act 16 review, requiring determinations on likely pollution or impairment and feasible and prudent alternatives to conduct under 17052. The Commission failed to make the required determinations. MEPA review is as broad as it needs to be to provide the public trust guardianship guaranteed by both the statute and the Michigan Constitution. This is not a sufficiency of consideration case. It is a Section 17052 determination case. The Commission's final order relies on arbitrary limitation of the scope of MEPA inquiry, disadvantaging appellants by blocking relevant evidence and failing to consider and make determinations on issues fundamental to the project purpose. The test for showing no feasible and prudent alternative under MEPA was established in Wayne County Health Department versus Olsonite. The PSC must fully evaluate alternatives for the continued transport in one location or another of petrochemicals in transit right this minute in the open waters of the Straits of Mackinac. MEPA, not the case law or Act 16, demands this full consideration. Thank you, Your Honors.
Any questions?
Questions?
No questions.
Thank you.
Thank you.
Good morning, Your Honor. Assistant Attorney General Daniel Sonneveld appearing on behalf of the Michigan Public Service Commission. To begin, I'd like to indicate a desire to reserve 20 minutes or so for Mr. Bursch. I've also been asked to introduce that Mr. Devin Sullivan, counsel for the Mackinac Straits Corridor Authority, is also present in this room too, if there were questions regarding that. To begin, I'm prepared to rely on my brief and answer any questions, but after listening to appellants, I want to just make a couple statements with respect to some framework issues that I think are important when analyzing this matter. I do believe, my client does believe, the only issue or choice before the commission in this matter was to either approve the application or deny the application. The effect of the denial of the application is that the existing seabed pipeline would continue to operate across the Straits of Mackinac. It would continue to run the product through that pipeline, and the risk of a spill still remains and exists there. Denial simply maintains the status quo with the pipeline continuing to operate on the seabed. However, if approved, the effect of the approval of the application would move that pipeline to a tunnel, thereby reducing the risk of the pipeline spill to the Straits. There was no option before the commission that would result in the ceasing of the operation of the pipeline. That's important, I think, because I hear the arguments raised by the appellants, and I think a lot of them seem to either rely on this assumption that there is a path forward in this case to shut down this pipeline, or that there was other options available to the commission. But the commission was looking at a 4+ mile segment only. Only the 4+ miles, again, that was identified in the application that was before the Public Service Commission. And when you strip away everything that was a part of that application and a part of this case, at its core, it remains a pretty straightforward Act 16 application case for the analysis of this application to replace this small segment of the pipeline. Based on this and the contents of my brief, I'm happy to answer any questions. I'm happy to cede my remaining time for Mr. Bursch, but I would ask that this court affirm the decision of my client, the commission, and move forward with the application being issued.
Questions?
Oh.
And we keep saying no questions, and that's a tribute to how excellent all the briefs are, really.
Oh, I've been through this. I understand you have all read the briefs, and
Sure.
thank you.
Thank you.
Good morning, Your Honors. John Bursch on behalf of Enbridge, here with my co-counsel, Sean Gallagher. Ashley Chrysler is also here on behalf of the Propane Association, Amiki. Happy to answer questions if you have any for her. May it please the court. Everyone agrees that the Great Lakes will be safer if the dual pipelines, which are currently on the lake bed of the Straits, are moved to a single pipeline in the tunnel. There's no disagreement about that, although you don't hear anybody talking about it on the other side today. But instead of supporting that safety upgrade, the interveners seek to use that 4-mile replacement, the safety improvement, to attack the entire 645-mile pipeline. You heard that from the very opening words of Mr. Rachensky when he stood up to argue today. They want to take out the entire pipeline. And that's mistaken for two fundamental reasons. First, if they prevail on appeal or back in the MPSC, then that's not going to stop the pipeline. It's going to continue operating, but it's going to do so on the lake bed when everybody wants it in the tunnel. The second is that, as their arguments make clear, what they're trying to do is revoke permission for the entire line. And there's a way to do that. They could have filed an action under Section 91 Sub 1 of the APA with the Michigan Public Service Commission, and they simply haven't done that. And so what they're trying to do is hijack this very simple proceeding and turn it into something else that they did not file. So I'm just very briefly going to correct some misconceptions that they may have about the case. First, the theme that runs through all of this is that somehow this is about the entire pipeline. And whether you're talking about the public need under Act 16 or talking about MIPA, we're only talking about the safety upgrade, the 4-mile replacement segment. So for example, the Michigan Public Service Commission correctly followed its own precedents, the two Wolverine pipeline cases and the Enbridge case that we cite on page 15 of our brief, that what they're limited to looking at is the proposed replacement project, just that 4-mile segment. And they concluded that there was a public need for the entire pipeline, only in dicta. That's not something that you need to address. The very small job of this court is to determine if there's a public need for the upgrade. And they don't even challenge that, nor could they, because Act 359 establishes the public need for the upgrade. We all agree that things will be safer if the dual pipelines are moved into the tunnel. So any evidence related to Line Pipeline as a whole had nothing to do with the public need inquiry. And the exact same thing is true of MIPA. Under the statutory language, this is 324.1705 sub 2, the question has to do with the conduct to be authorized or approved by the proceeding and whether that is likely to impair the environment. And the commission correctly concluded that the conduct at issue is the safety upgrade, this 4-mile segment of the pipeline. So again, evidence related to the pipeline as a whole is extraneous and legally irrelevant to answering that question. So you put those first two pieces together, public need only involving the safety upgrade, MIPA only involving the safety upgrade. What that means is that operations of Line 5 as a whole simply aren't at issue. The commission correctly did not have to consider those. Mr. Rachensky said that Enbridge put the whole pipeline at issue. That's simply not accurate. They pick a couple of sentences from a multi-thousand-page record to try to make that case, but Enbridge only wanted to get the replacement project, the safety upgrade approved. And if Enbridge knew that this proceeding was somehow going to turn into a referendum on the entire line, it never would have filed it. It would have just allowed the dual pipelines to continue operating on the lake beds, even though everyone agrees that putting them in the tunnel will be safer. In fact, there's no company, whether it's a pipeline company or an electric line transmission company, that would ever seek to improve safety or replace or maintain a line ever if they knew that going forward with that application was going to put the entire existing transmission line or pipeline at risk. That's simply absurd. You also heard Mr. Ranchensky say that somehow this will extend the life of the pipeline. That's not accurate. The easement agreement that Enbridge has from the state of Michigan is indefinite. It goes on in perpetuity. And when you're talking about the dual pipelines that are on the lake beds, pipelines are not like our bones, where after 75 or 100 years they get brittle and they're prone to break. The pipeline on the bottom of the straits is as intact and operative as it was the day that it was installed. It doesn't degrade. It doesn't break down. That's why PHMSA, the federal regulatory agency that regulates the safety of pipelines, has continued to give a green light to the pipeline, even operating on the lake bed. His closing comment was that the alternatives did not consider Line 5's operations. Well, that's true, because as we've discussed, those were wholly outside the scope of these proceedings. Now, Mr. Granzato said that the greenhouse gases would go down if the project was denied. Again, that's not accurate, because the no alternative here, if the application had been turned down, is the status quo. The line is going to continue to operate on the lake bed, even though everybody would prefer for it to be in the tunnel, because that's safer. And that's why all the alternatives fail, because if the no action is the continued operation of the existing pipeline, any of the alternatives inevitably, ineluctably, will increase the negative impact to the environment. That wasn't difficult for the commission to conclude. He also says that the burden of proof shifted to Enbridge to prove that the alternatives would have made things worse. We don't disagree with that, and neither did the commission. 6 times in their 352-page opinion, they referenced the burden of proof, which is proof by a preponderance of the evidence. And even if they didn't use those precise words in the place that Mr. Granzato would like it, doesn't mean that they misanalyzed this project, because they looked at the evidence for all the alternatives that the plaintiffs wanted them to consider and concluded that each one was worse than the alternative, which is simply leaving the pipelines where they are. Finally, Ms. LeSueur talks about again, attacks on Line 5 as a whole. Those are just completely out of scope for the reasons that we've talked about. There was no need for additional discovery or additional evidence on any of those things, because the bottom line is the status quo. Things continuing to operate as they are. You'll hear this talk about the governor's notice. That wasn't self-executing, and no court has ever ordered the pipeline to be shut down. Judge Jamo is considering that argument in the lawsuit that the Attorney General brought in the Ingham County Circuit Court. And inevitably, that issue is going to get to this court. And maybe judges on this panel, maybe a different panel, are going to be able to consider the merits arguments about whether Line 5 as a whole should be kept open. But that's not what this proceeding is about. You just have a very simple job, and that's to ask whether the MPSC erred in saying that the replacement project had a public need and resulted in an improvement of the environment rather than an impairment of it. So unless you have any questions, I guess in conclusion, I would just reemphasize that this litigation has nothing to do with the public need for or the environmental impact of the entire Line 5. If it does, we'd withdraw the application today and just keep going with the status quo. So Judge Jamo's action is going to give the court to answer the kinds of questions that plaintiffs, or I'm sorry, interveners would like you to answer. This appeal involves only whether there's a public need for the safety upgrade of moving the pipeline to a single underground pipeline, and whether that upgrade is good for the environment, which everyone agrees that it is. The MPSC bent over backwards to allow the interveners to present as much evidence as they possibly could have, and still easily approved the 4-mile replacement segment. This court should summarily affirm in an unpublished per curiam decision. There are no questions. I think we're happy to just relinquish the remainder of our time to the court. Thank you, Your Honors.
Thank you.
Buttle?
Few brief points, Your Honors. First, I'd like to address the statement by Enbridge's counsel that the public need finding is only considering whether to place this pipeline in a tunnel, whether that's an improvement on safety. It's not what the commission considered and analyzed in its public need finding. It made it a two-part finding. First, and it's on page 305 of its order, stating the commission finds that the Enbridge has established both the public need for the products to be shipped through the replacement project and the need to relocate the Straits Line 5 segment in the tunnel. So the commission made those findings on public need. It wasn't just let's look at whether they should go in the tunnel. They looked at whether there's a public need for the products to be shipped after barring interveners from submitting that. That's an APA violation, as we covered in our briefing and as I discussed earlier. Next, I'd like to address the idea that we've sought to revoke a license to operate Line 5. They cite no filings of any intervening parties in this case that have sought that. It's a misconstruction of our arguments. We merely seek to put on a full case before the commission and create a full and fair record to seek a denial of this application. We're not seeking to shut down Line 5 in its entirety in this proceeding. And finally, I'd like to address this idea that under Act 16, I think it's a slippery slope fallacy that no one will seek to replace or repair pipelines if it puts the whole thing up in issue. This case is really in a class of one. This is a pipeline replacement segment case dealing with a segment that has had its easement revoked and is subject to a separate lawsuit to shut it down. They would not have a chilling effect on transmission projects for electricity or for pipelines in the state of Michigan if you were to rule for interveners in this case that it needs to go back to the commission for a full and fair hearing. And to conclude, the tunnel project is a massive and disruptive undertaking through the heart of the Great Lakes and the center of the Anishinaabe creation story, and whether there's a public need to greenlight such a thing must be the subject of a full and fair hearing. That didn't occur in this case, and the court should fix that by sending it back to the commission to allow parties to put on their case about it. Thank you.
Thank you.
Are there other rebuttals?
I would like to make only one point. The suggestion's been made here that we are talking about 4 miles, and that's the only thing we're talking about. I would suggest to you that once the commission says that the products flowing through this pipeline must be considered under both Act 16 and MCOA, that this case is no longer about 4 miles. It is about what happens once these products flow through that. And that's exactly what the commission said in their April 21, 2021 decision. And they did not follow through. That's my simple point. Thank you.
Your Honors, I just wanted to point out again that page 329 of the commission's final order held that construction of the tunnel will or is likely to cause pollution. And under MCOA, that finding requires certain additional consideration, and that consideration has to be a full evaluation of feasible and prudent alternatives to determine whether or not that that damage, that likely pollution is justified. That's what we didn't get. That's what we request remand to bring before the commission. And on behalf of Flow, if withdrawing the tunnel proposal is now on Enbridge's mind, we certainly endorse a more careful look at this misguided project. Thank you.
All right, thank you.
Thank you.
I guess that concludes this. Case will be submitted. Thank you all, and I'll say it again, if you didn't hear a lot of questions back and forth, it's only because you all filed very extensive and excellent briefs, which are extremely helpful to us. So thank you all. And this will be submitted.
A little sore from all the abuse.
Slow moving crowd. Doors are shutting, so we can move on to item number 2, which is docket number 371,352. That is People versus Michael David Brachfeld.
Morning, Your Honors. May it please this court. My name is Tim Flynn, and I represent Mr. Brachfeld, the appellant in this matter. I would like to reserve 5 minutes.
Excuse me one minute. Mr. Jones, could you ask those people to maybe move out into the hall? Maybe, looks like maybe they're going now. I think we're okay. Sorry about that.
As I was saying, Judge, I just wanted to make sure I reserved 5 minutes to rebut the prosecutor's comments in this appeal. Your Honor, we're here today. We have a ruling. This is a case very unusual in my 39 years of practice. I've never seen a CSC case, and there are 9 counts at issue here, 9 counts of CSC 1, where there has been so much evidence of prior false allegations of sexual assault involving the complainants. We've made an offer of proof below, and the reason we're here today is we used the Butler proceedings. And Butler's an unusual case because, as this panel probably knows, once the Supreme Court sent that case back down, the prosecutor dismissed the case entirely, and they sent it down to this court with instruction to the lower court to establish an evidentiary standard for the in-camera hearing that goes on now, or at least the Supreme Court has suggested that it should go on when there's cases like this one where we're faced with prior false sexual allegations. We're here also because I think this panel on my application was interested in finding out, what the standard should be. You look at the lower court's ruling, Judge Kavanaugh's ruling was equivocal. She seemed to say that we may have met our burden with regard to the girl's testimony on within the hearing that we conducted, the Butler hearing. They said that they were instructed by their mother to make false allegations of sexual allegations against their father. However, when she started to focus on 608B, then she started to equivocate below, and she seemed to indicate that, and I wrote down one of her comments, there's no evidence of false allegations came out of this witness stand. They don't remember, the girls didn't remember specifics. So we think this is more of a MRE 404B case. My client has a right to confrontation under the United States Constitution. In this state, he has certainly a right to present a defense under Article 1, Section 13. These are important constitutional rights that involve cross-examination. We don't just want to be limited to the lower judge's ruling. If you read her ruling carefully, she seems to indicate that maybe we can ask some questions about their mother putting them up to making false allegations, but anything involving the CPS reports, she doesn't want to allow. She also indicated that that's going to be a trial decision, which I understand, but I think after you look at Hackett and Butler, this in-camera evidentiary hearing is important. We need a ruling to come out of that. And this panel wants to know also, one of the other deficiencies we think of the lower court's decision was there was no evidentiary standard articulated when she ruled. So we don't know whether we can ask these girls about the complaints that they made about their dad. We don't know how far we're going to be allowed to go. We think we should know. We think that we should be able to fully cross-examine the girls, both as to their now sworn testimony that involves, and I'll just, my brief pulls out the excerpts. I mean, I think the first question from each young girl is important. I'm going to refer to, these complainants incidentally are twins. The one complainant I'll indicate is NR. And I'll just read the first question. Question, we asked her at the evidentiary hearing, do you recall telling the forensic interviewer that your mom had told you to make allegations against your dad? Answer, growing up, I was persuaded a lot by my mother to say things about my dad. Question, and to say things about your dad that weren't true? Answer, yes. Her twin sister, sequestered, came in next, also testified. Her initials are KR. It's in my brief, but I'll just read the first question. It's important. Question, and she, her mother, Bobby Jo Holland is the mother I put in brackets, she told you to say that your dad was doing sexual things to you when he wasn't. Answer, that's correct. So the lower court seemed to indicate in its ruling that we might be able to impeach the complainants on those points, but there's a lot more to it. And I laid it out in my brief. This brief has a dozen bulleted points that brings out through two exhibits I put into the lower court record that involves CPS reports, all of which ultimately were unsubstantiated, most of which involved allegations by these twins, the complainants in this case, against their father. One of them even involved some comments about defendant. And they, at some point, they even got going on weaponizing allegations against their own mother. That's all in the CPS complaints. We want to be able to question them thoroughly based on my client's constitutional rights that I've mentioned as to all of these complaints. We understand that they might not have good memory. And on that point, I think it's very interesting to point out to this panel regarding these witnesses, when they had their preliminary examination, when Mr. Brachfeld's preliminary examination took place about a year and a half ago,
Remind me how old they are now, the twins?
they are adults. I want to say 21, maybe even 22. You heard something, I know somebody's behind me making comments, but in any event, at the time of their preliminary examination, their recall was almost perfect. They could recall the temperature of the water, the look of the room, the clothing that the defendant was wearing, clothing that they were wearing, the custody arrangement of their parents at that time, the parenting schedule. They could remember everything at the preliminary exam. When it came time to this evidentiary hearing, they equivocated, but I read to you just now the key points that at a minimum, to not allow that type of testimony into the trial in front of the jury to consider is an absolute dissolution of my client's right to confrontation of his accusers, as well as his right to present a defense under the Michigan Constitution. With regard to that right to present a defense, I think it's important for us to know now, not at trial, but to know now whether we can call Mr. Rayburn. He's the complainant's father that was the subject of this series of weaponized CPS allegations. Whether we can call the complainant's mother. We need to know that now, not at trial, to be told no by the lower court judge. No, that's not relevant. By the way, counsel's going to get up here and argue, you know, we understand that the defendant has constitutional rights, but this has to all take place pursuant to a specific rule of evidence. And what we are asserting is that we're focusing on MRE 404B. This court, and I'll get to it in a minute, this court and the Supreme Court have recognized that being able to cross-examine complainants about false sexual allegations that took place prior to the charges in any particular case is a legitimate purpose to prove a scheme, to prove a plan under MRE 404B. And that's what we're trying to do. So I mentioned the preliminary exam and all the detail that came out to compare it to the subsequent evidentiary hearing involving these prior sexual allegations, because if they testify that they don't remember part of the 404B scheme and plan, I think will have to include calling the complainant's father, calling the complainant's mother to fully flesh that out. The reason why we're here and why I think this court has granted leave is that for these in-camera, closed court evidentiary hearings, there's no standard that is associated with when you have satisfied the burden and what burden that should be for you to proceed to trial, knowing that you're going to be able to cross-examine the complainants about A, B, C, or D prior events that were proven false. As far as the level of proof that it takes to prove that they were false, again, I think that, it's impossible to prove a negative. I think that what the prosecution, if they get their way and they say that this court should remand with instruction to have a intermediate burden of proof, a clear and convincing burden of proof, why should a defendant accused of this type of crime have any other additional burden than any other person, any other accused that is using MRE 404B? It shouldn't. We think that the preponderance standard is fair. The accused rights of privacy are protected. That's why we have a closed court hearing prior to trial for the trial court to figure out, okay, what are these witnesses going to say? What's the evidence? So those rights are protected. This is not a fishing expedition. When we made the motion below, and I think you're probably going to hear it, but when we made the motion below, the prosecutor indicated that we were embarking upon a fishing expedition. It's in the prosecutor's brief. This is not a fishing expedition, and the lower court acknowledged as much in the excerpted portions of her ruling that I put in my brief. She doesn't think it's a fishing expedition. It's just that she was very, very limited in what she believes would be allowed at trial with regard to this onslaught, this telephone book full of sized parcel of documents that we have, that these particular complainants lodged false allegations about many other people in their past. Those allegations were weaponized. We saw in this court, in the record doesn't contain all the rich detail, although the CPS reports are part of the lower court record, but they definitely allude to a plan and a scheme. That's what this was. I want to get to some of the cases because they're similar. This was a plan and scheme by mother. And you have a case, Judge Kelly, you were on the panel, the Rogers case. That case, I want to just read a quick excerpt of your decision from that case. A criminal defendant bears a heavy burden when seeking a new trial based on newly discovered evidence. This is especially the case when the newly discovered evidence consists of recanting statements that are largely hearsay, and even more so when the recanting statements are themselves recanted. But a heavy burden does not mean an impossible one. This case was cited in the Mathis Butler Court of Appeals panel that ultimately got reversed by Butler at the Supreme Court. But this particular case has a scheme or a plan. And again, there are cases also that indicate that when you are trying to show that the complainants have made false sexual allegations in the past, MRE 404B is an appropriate method and a legitimate evidentiary pursuit to undergo. The case that cites, there's two actual cases that cite 404B explicitly. One I think is of note The Jackson case is a Supreme Court case that came out of Oakland County. Jackson's kind of interesting because this court, the Jackson panel from way back in 2003, indicated that, the evidence was relevant about, it's another one of these cases where you had a father of the complainant directing the complainant to make allegations for those people that he disliked. That's very similar to our case. And this court said the evidence was relevant but overly prejudicial under MRE 403. Well, this court's panel in Jackson was overruled by the Jackson court, 475-909, 2007 case, which said it ultimately held, the Supreme Court held, upon retrial, defendant must be afforded the opportunity to introduce testimony that the complainant has previously been induced by his father to make false allegations of sexual assault against other persons disliked by father. And then it cited 404B. That's what we want to do. That's what we should be able to do under the Constitution of the United States that allows somebody to confront their witnesses and conduct full cross-examination about this litany of CSC complaints orchestrated by mother, weaponized by mother, using her twin daughters as agents. And that's also what we need to do if the Michigan Supreme Court, if the Michigan Constitution's right to put on a defense means anything at all. 404B is the avenue by which we are allowed to do it, contrary to what you're going to hear from Brother Counsel in a minute. So Judge Kelly, you were on the Rogers panel. That case cited to, you were on that panel, but the procedural background in that case was a little bit different because there was that was a motion for a new trial. This is a little different. This now, that was pre-Butler. Now that we've got Butler, this case is the only one that I know of where the rubber's meeting the road on the issue of what is the evidentiary standard to use in these in-camera, private, closed court evidentiary hearings to determine the veracity of or the falsity, if you will, of the false allegations and to decide if they can be used for a proper evidentiary purpose, which, again, I can't say it enough. We're relying on MRE 404B and 608B as well. The lower court was very equivocal on its discussion of that court or that rule of evidence. I think where that comes in is we would like to introduce the extrinsic evidence of Mr. Rayburn and Bobby Joe Holland to find out, what, Mr. Rayburn, were you accused by your daughters of sexual assault, and were you investigated by CPS? Yes. We know, this is why we're not conducting a fishing expedition now. We know what was done there because we have the benefit of the reports. The jury doesn't get to see those reports. We understand that. But we certainly think, especially in light of the girls' lack of memory when it comes to other sexual assaults that they claim, that we should be able to use the extrinsic evidence of Mr. Rayburn's testimony as well as their mother. Beyond that, if this, I want to just emphasize in closing, I want to rely on this court's Rogers panel that Judge Kelly was on, and in the Mathis Butler, even the Mathis Butler panel of this court that got reversed by the Butler decision. That was Judge Kelly, but I think it was Frank Kelly on that panel. Both of those cases recognize, they cite Rogers and they cite 404B. That's what I'm trying to say. Both of those cases indicate that substantive evidence of a plan or scheme per 404B is what's at play when you have testimony where a complainant admits that they lied about some type of prior allegation. In this case, there is some recanting going on. I just read it to you. They said, our mother told us to lie. was that true? Did anything happen between you and your father? No. So that's a recantation. I don't know how much more we can prove the falsity of it. It should be allowed to go in. And with all of that said, if this panel has any questions, I'd be happy to answer. I'll just reserve my time for rebuttal.
We don't have a lot of questions today.
No, I figured that we would take the brunt after that massive argument, but I'm more than happy to answer questions if the panel had any.
352-page opinion in that case. Shorter than the one you were just saying that I was on, I'll tell you that.
Good morning. May it please the court, Brandon Ciciotti, Assistant Prosecutor for Livingston County on behalf of people of the state of Michigan. And now I'm worried I'm going to take the brunt of the questions. So, for there to be prior false accusations of CSC, two things have to be true. The prior accusations have to be made and they have to be false. If you look at the record from the in-camera hearing in this case, the only evidence that was presented at that hearing was the testimony of the two complaining witnesses who said their testimony was, we remember our mother trying to persuade us to make accusations against our father. If we made them, they were false, but we don't remember making them. Based on that sparse record from the in-camera hearing, the trial court correctly ruled that there was no evidence that prior false accusations had been made. So I think that the solution to this appeal, to the case that's before the court, is simply to affirm and to remand. It's possible that a broader record could be made upon, when the case is remanded in front of the trial court. Other things like the CPS records can be looked at and the court can make preliminary factual findings to determine whether more evidence is admissible under 404 or 608. But based on what has been presented already, the court correctly found that there were no prior accusations made. At least there was no evidence of that. Now, Brother Counsel wants this court to rule on the admissibility of that evidence, at least if I'm understanding correctly. But there have to be factual findings, which would be the proper role of the trial court, and the trial court just didn't have enough information to rule on the admissibility under those rules of evidence. Specifically, I know that Rule 404 was mentioned. It's not sufficient for a party to just articulate a proper purpose. That there actually has to be that connection shown. In this case, specifically with regard to common scheme or plan, there's just been no evidence that that's the case other than it just being articulated by the defense, especially when it comes to common scheme or plan. For that theory of relevance, the evidence between the two separate instances usually have to have striking similarities. And I think there are a lot of differences here, or at least the similarities haven't been put into evidence for a court to properly rule on admissibility under that standard. For instance, the defense says that the prior accusations were made at the mother's behest against her ex-husband, and now they're being made against the defendant. But there's no record in the evidence. There's no evidence in the record, and no evidence that I'm aware of that there was ever a romantic relationship between the mother and the defendant. The prior accusations were made when the girls were, if they were made when the girls were toddlers. These accusations were made when they were young adults. The prior accusations, if made, were prompted by the mother. There's no evidence that the mother was involved in these accusations at this time. So there's a lot more fact finding that needs to be made before ruling that the evidence can come in under 404. So I think just based on that, I think that the proper thing to do in this case would be to affirm and remand. And that opens up now the question that I think the court needs to answer is, first of all, should the court articulate the standard, the question that was left open in Butler of what the proper standard of evidence is, what the proper standard of proof is. The court can do that, or it can leave it to the lower court to articulate that in the first instance, because there wasn't even a prima facie showing that prior false accusations had been made. I don't take a position on whether this court should answer that question or just leave it to the lower court. I would just state, based largely on the reasons in my brief, that if the court does want to articulate a standard, it should be the clear and convincing standard. A few years ago, the Michigan Supreme Court said in the case People versus Taylor that that is the appropriate standard when there are particularly important interests or rights that are at stake. And I understand that we're talking about a defendant's right to confront his accuser, and that is an important right, but it is subject to the rules of evidence. And for reasons largely stated in Hackett, this is not the kind of evidence that is particularly probative. That's why it's not rape shield evidence, but it is similar to rape shield evidence, and that's why evidence that is barred by rape shield, Hackett concluded was that was not unconstitutional for the legislature to do so. It did not violate the defendant's confrontation right. And what is important is I think there are a lot of practical considerations, a lot of private and public policy interests that are implicated by this kind of evidence for, again, reasons I'll just rely on in my brief. And one reason that I unfortunately did not include in my brief, but I think is worth mentioning today, the Michigan Constitution Article of 1963, Article 1, Section 24 enumerates the rights of crime victims. And the very first one listed is the right to be treated with fairness and respect for their dignity and privacy throughout the criminal justice process. And I don't believe that crime victims are treated with dignity if they are accused of fabricating claims of sexual assault without sufficient evidence that they are doing so. And I don't think that respect is shown for their privacy by digging up their sexual history and past victimization without very good reason to believe that that past has been fabricated. And I want to bring up also, and I'll just leave it at this, unless the court has questions for me, that this is also an unusual case, as Brother Counsel said. And the reason, I think that one reason why it's very unusual is because there's not a question that these girls were not victims of CSC by their father. The question is whether they actually accused their father of CSC. And at least my intuition is that in most cases where this question comes up, it's going to be the opposite, that there was a prior accusation, and the question is whether the accusation was true or not. And if it turns out the accusation actually was true, then that is evidence of a victim's prior sexual activity, albeit not consensual, but then the rape shield statute is actually implicated. So I think that those are all good reasons why the standard should be clear and convincing, not something lower like a preponderance. I'll leave it at that unless the court has any questions for me. Thank you so much.
Thank you.
Brief rebuttal.
Very brief rebuttal, Your Honor.
We do recognize that alleged victims of crime should be protected and recognize Section 24 of the Constitution. However, false rape allegations have led to wrongful convictions also. And this area of prior sexual allegations that have been proven false or are deemed false is a big issue. This court has been reversed many times by the Supreme Court. Trial courts are routinely reversed on this issue. And this panel wanted to know once and for all, I think, because Butler didn't go all the way due to the prosecutor's dismissal, what is the evidentiary standard that comes into play? For Brother Counsel to say that there's no evidence, and I noted and I read that the lower court also seemed to say that there was no evidence of prior sexual assault, false prior sexual assault, although then, unlike Brother Counsel, the lower court then seemed to also recognize that the complainants essentially recanted what they may have said to CPS. The record below, in terms of trying to make a showing, counsel and I both agree that this should be remanded with instruction to the lower court to complete this hearing now that we know what these complainants are going to say. But my brief before this court bullet points a lot of specificity that are contained in the CPS reports. So to say that there's no evidence, the pro-offer is there. It's just that, again, the complainants they have selective memory. And for that reason, we should be able to fully cross-examine not only them, but bring in witnesses under the 404B theory. And that in no way detracts from their interest, the social interests involved in, under the rape shield. Everybody agrees this is not a rape shield case because this is not about sexual conduct. This is about false prior sexual allegations. It's a completely separate issue. So that doesn't come into it at all. And again, I think that the competing interest is that people lie under oath when it comes to sexual assault allegations. That's a really important thing to notice and to take note of. This court has, the Supreme Court has, that's why we have Butler. And that's why we're asking this court again to remand with instruction to allow us to fully cross-examine these complainants, to bring in their parents, to flesh out where the complainants have selective missing memories. And that and only that would allow a full and fair trial for Mr. Brachfeld. Otherwise, his constitutional right to put on a defense and to properly confront his witnesses with effective cross-examination is meaningless. Thank you, Your Honors.
Thank you. That
Thank
case
you.
will be submitted.
I'm sorry, did you?
No, I said the case will be submitted. Thank you.
Thank you.
That brings us to item number 3, docket number 369590, People versus Chad James Febre. Just received word that Ms. Matthews has waived oral argument.
Very good. Your Honor, obviously, this is a very narrow issue, just particularly addressing the scoring of the guideline of OV10 for this particular defendant.
Could you put your name on the record?
Yeah, I'm sorry. Sure. Mark Linton up here on behalf of the appellant, Chad Febre. I'll just make a couple of quick comments. I know you've read the briefs. I would just note that it's interesting that people don't even really try to address the merits of the argument of OV10 being applied to Mr. Febre. Instead, they tried to basically say that because his trial attorney didn't bother to review the PSI and bring it up as an objection or, in front of the trial court at sentencing, that should be considered waived and that he should be stuck with that particular scoring. I believe that this scenario clearly rises to the level of plain error because it affects his substantial rights of being sentenced under accurate information by the trial court judge. Because if it had been scored correctly, I have no doubt that it would make an impactful difference in a sentence to him, because every day spent in prison, obviously, is meaningful. So I think it's a simple solution for the court to remand this matter for resentencing. And I don't know if you have any questions.
No, I don't.
No question.
So, all right, thank you.
All right, item number 4 is docket number 367241. It's People versus Andre Lee Coleman.
Good morning, Your Honors. Jeffrey Rupp appearing on behalf of appellant Andre Coleman. I only have a few comments, I think, in response to the pleading from the prosecutions, primarily with some of their statements of fact. There's an indication that Mr. Coleman pled to the underlying charges that he was on bond for at the time that the contempt was found, and that he has not appealed that conviction or sentence. I'm not sure that it's relevant to our considerations. I don't think that it cures any of the due process errors that we're claiming. But to the point that I'm missing something, I would note that just last week, I did accept appointment to represent in that matter. The prosecution argues that Mr. Coleman has a copy of the police report when he appears before the trial court on May 5th, which was the initial scheduled date for the hearing, pushed off for about 12 days because new counsel had been appointed and indicated that they had just received that police report. I think it misrepresents, or it certainly I read Mr. Coleman's comments on the record to indicate something different, that he was offered a brief opportunity to skim through the report that morning, but had not yet received a copy himself. And counsel states on the record that he had just received it that day. The point is made that counsel at that date, on that date and time, indicates that he was prepared to proceed with the hearing should the court have done so. But importantly, Mr. Coleman did not say that, and certainly argued that he was not. So again, just in summary, it's our position that there were a number of defects procedurally, and that the bench warrant was issued without an affidavit. He was not given proper notice. He was never formally arraigned. I think on any of the accusations, there is a comment, or the trial court reads the bench warrant or the bench warrant to him at the May 25th hearing, but it's simply that you were in violation of your bond because you had contact. There's no specificity of what type of contact, when or how it occurred. There are comments on that date that there are a new alleged violation for additional contact just the day or the evening before prosecution concedes on the record at that time that he should be arraigned on that. And that is never covered on May 25th or on ultimately the hearing on June 6th, other than through the testimony of the complaining witness. I think those are all the comments that I wished to make in response to the prosecution's pleading. I welcome any questions you have.
Quiet group.
Thank you.
I was surprised that the group here this morning wasn't here for my comments on contempt.
Sticking around. Yeah. Thank you very much.
Thank you, Ron.
All right, that brings us to item number 5, docket number 366,923, People versus Eddie Lee Smith. I believe this is a remote argument.
Good morning. Please the court, Drew Walbeck on behalf of Eddie Smith.
We're not seeing you.
Turn on your video.
There you go.
Okay. I could see myself.
No, we see you fine.
Okay. So first I want to thank the panel for permitting me to appear remotely today. I will be very brief. My client was actually paroled about 5 months ago. And in order to be paroled, the parole board had to find that it was reasonably assured that he was not a danger to the public. Despite that finding, he must continue to register as a sex offender for the rest of his life, reporting on, pretty much all aspects of his life, any vehicle he drives, any phone he uses, his residence, his employment address. And so despite the parole board finding he's not a danger, he must continue to follow those burdensome requirements. And so for all of the reasons, I've briefed, I think those requirements are excessive and unreasonable. At the same time, the court is obviously bound by Kaczynski, which was also my case. And so, I do believe for all of the reasons that you, Judge Kelly, put in Lyman 1, I think Kaczynski is incorrect. And so I do believe that the panel should call for a vote for a conflict panel. But I will otherwise rely on my brief unless there are questions.
Is there an application in Kaczynski?
I filed it last month. There's been no word yet. But under the court rules, until leave is granted, the court can call for a panel.
Right.
Okay, well, we'll wait, see what happens with that. I mean, I don't know that we're gonna hold up this opinion to do it, but as you said, what I said in Lyman, so you know where I stand on it, but I think I'm kind of strapped in by Kaczynski at this point. So we'll.
Correct, except for your option of calling a conflict panel, yeah.
Yeah.
No questions.
Okay, well, thank you very much.
Thank you.
Thank you, Your Honors.
That case will be submitted. Brings us to item number 6, docket number 368031, the Truman Harrison and Modesta Harrison Trust. And again, we have a remote from Ms. Cruz.
Good morning, Your Honors.
Morning.
I'm not sure if you can see me or if.
No.
Do I start my video? I'm sorry.
That's okay. It happens all the time. These things are a little tricky if you're not used to them.
I'm not used to them at all.
Well, we see and hear you, so go right ahead with your argument.
Well, my argument as far as the removal of my position, as noted, was that due to the attorney that was representing me at the time could not attend for her own medical reasons, and that I also was not notified of this particular case in regards to removal of my position because it was based on other motions that were filed. During the whole situation with the Truman and Modesta Harrison, I'm not sure if this court is aware of it, but it has been a severely troublesome trust due from previous beneficiaries, not allowing certain procedures to proceed as far as providing documents, return of documents that I had needed at the time to move forward with doing this trust. Since the passing of one of the siblings, it has gone back and forth to the lower court as to trying to determine whether or not, according to the terms of the trust, that his portion would be, he would be entitled to his portion or his estate. We did have an agreement in October of 2020 that all the beneficiaries, including the deceased at the time when he was represented by their attorney, that the terms of the trust and time of lapsing had expired. At that time, everybody understood the terms of the trust, agreed to the terms of the trust, and therefore I moved forward. After the sudden death of my brother, his attorney and his other client's attorney, Mr. Wallace, continued to represent them. And my brother passed away in July of 2020. I'm sorry, 2021. In August of 2021, I received a message from a beneficiary who agreed to the terms of the trust that his portion would then in turn be passed on to the remaining surviving beneficiaries. He in turn also, I had an hour and a half extensive conversation with another beneficiary who in turn also agreed that that was the intent of our parents. Since that, Ms. Zalewski, since I was told that the majority was in the agreement, that I contacted her as soon as possible, asked her to propose the final distribution to the remaining surviving beneficiaries, which she did so in a letter dated in September of 2021. She forwarded that information to Mr. Wallace, the attorney for the beneficiaries, the remaining beneficiaries, and he then in turn forwarded to his clients her proposal for the final distribution. That distribution, he forwarded that letter also, I'm sorry, to his clients, and he also forwarded the information to the spouse of my deceased brother, who was not a beneficiary at that time, or is not a beneficiary of the trust at all. October, when Mr. Wallace sent this letter, stated and sent the form for the waiver to consent to the final distribution and closing of the trust, but then in turn signified in this letter of his concerned issues regarding whether or not Kenneth Harrison, the deceased beneficiary, portion should in turn be turned over to his spouse. I'm sorry, I'm going to get really emotional. Mr. Wallace included, as I stated, Miss Elizabeth Harrison, who is now appointed the special fiduciary to take over this particular case. As I stated earlier, it's just been an ongoing battle prior to my brother's passing. And upon final resolution that they all agreed, it has just been a webmire of litigation that was brought and has been brought by Elizabeth Harrison, stating that my brother's funds should go to her. After we received notice that Mr. Wallace was no longer representing his previous clients, which were beneficiaries of the trust, he then announced that he was representing the estate of Kenneth Harrison and Elizabeth Harrison, his wife. It was clear that during the process to attempt to close his trust, that Mr. Wallace was in turn providing information and consulting with Elizabeth Harrison in regards to the Harrison Trust prior to his representing her and the Kenneth Harrison estate, which I feel was a conflict of interest. Again, at that time, all of a sudden, his previous clients, which would be Michael Harrison, Kathleen Linder, and David Harrison, were no longer represented by Mr. Wallace. So I continued to reach out with them with no avail. They would not respond. They have not responded to the second successor, Barbara Harrison Chandler, who I would add was not appointed according to the terms of the trust upon my removal. Currently, because of, I'm going to backtrack a little bit, excuse me. After receiving notification that the majority of the beneficiaries wished my brother's proceeds to follow the terms of the trust, which stated if one should die, that their portion would go and be distributed and divided between the remaining primary beneficiaries, which in turn was my parents' intent. I had meetings with my parents prior to their passing several times, kept updated as to their wishes, made sure that I followed their wishes, attended meetings with the company and the individual who prepared their trust, along with my mother prior to her passing. I had submitted an affidavit to the lower court stating that he witnessed and was present at the time when we reviewed her trust. His affidavit in turn was disregarded, stating by Mr. Wallace that he was not an attorney, despite the fact that it was a notarized affidavit that at that time Mr. Crandell, who was the CEO of the company in which my parents established the trust with, verified the actual intent of our parents. During evidentiary hearings and previous hearings, the second successor, Barbara Harrison Chandler, was not permitted while waiting in the waiting room to partake by phone. She was not admitted. During the current and past evidentiary hearing that the lower court has continued to approach me with, was not permitted to testify or to speak during that evidentiary hearing. I guess the bottom line is I did everything that our parents wished, everything that the majority wanted, left communications open at all times to resolve issues. We also had in October of 2019 an agreement that was filed with the lower court with the previous judge, which was Honorable Judge LaCrosse, which currently the lower court's judge has set aside, which has only allowed this to go on and cause expenses, damages to the trust, has disregarded the intent of our parents, has destroyed our family. The second successor I have continued, and during the duration of the administration, the trust was in constant contact with. At this time, she is aware of the current pending charges against myself for failure to do my fiduciary responsibilities in entrusting Ms. Ilowski with the remaining funds in preparation to close the final distribution in December of 2021. The second successor, because of everything, all the threats that her and I have entailed, of not doing certain things, destroying certain documents by other beneficiaries that were recorded, because we stood fast on our parents' wishes. She at this point does not want anything further to do with this trust. She and I both have received multiple threatening phone calls, text messages, everything humanly possible that they could throw at us so that they could have their way. Even after this agreement was filed with the court in October of 2020 or 2019, I'm sorry. In regards to my appeal, I do feel that there has been a lot of bias in this administration of this trust from the lower court. And that he has not reviewed the trust as a whole, has not harmonized what our parents' wishes were. And because of what Ms. Ilowski has done, has caused irreplaceable damages to myself, repercussions that I'm now facing. I have since then, despite my removal, have contacted the necessary authorities. I've contacted the prosecuting attorney's office, the state police office, in the process of approaching the attorney general's office. The special fiduciary that has been appointed.
Miss, can you hold on 1 minute? I think one of the judges here has a question for you.
Sure, I'm sorry.
That's okay.
Do you know whether any of the victims in this case have submitted a claim to the victims fund for reimbursement?
I did contact the Client Protection Fund, and at that time, I contacted them immediately after I heard of what had taken place. They said at that time that nothing had been filed, so they forwarded me the information to fill out in return in regards to the status of Ilowski's representation. Ms. Ilowski was ordered by the lower court to turn over all her client's files. She refused to do so. So I do not have that information to follow through.
Do you know whether the special fiduciary has also contacted that entity?
The special fiduciary at this time, since her appointment, has not notified me nor the second successor of her actions since her appointment.
Okay, thank you.
You're welcome.
Is there anything else you wanted to add?
Yes, if I may.
Okay.
When I questioned during the evidentiary hearing, this past one in August, as to why the special fiduciary has not contacted or why beneficiaries aren't aware of what, I'm sorry, of what the beneficiary's special fiduciary is doing at this time, we were instructed by the lower court that it is our responsibility to Google it, to see what is taking place in the circuit court in regards to Ms. Ilowski, which I feel that it is not our responsibility. It is the responsibility of the special fiduciary to keep us informed. We are still remaining beneficiaries and interested parties in this trust. I have offered at that time to assist in any way possible so that we can bring conclusion and justice for the trust estate. Reached out to the special fiduciary's attorney at the time, made those offerings, and have not received any contact from them whatsoever, nor has the second successor, Barbara Harrison. I also inquired as to funds that were transferred by the lower court from Ms. Ilowski in the amount of $25,000, and asking if the beneficiaries had a right to know where those funds were being held, and if Mr. Wallace in turn allows his clients to know where those funds are, and he stated no, that I had no right to know where funds are kept, whether it be in reference to the $25,000 that he received and the special fiduciary received, or in regards to any other pertinent client that he may have had. It is obvious that the beneficiaries that Mr. Wallace once represented are still in contact with him and the special fiduciary. And again, myself and Barbara Harrison Chandler, second successor, are being totally left out, completely left out. The second successor has reached out to the special fiduciary by phone call, and the special fiduciary at this time has not returned her calls. I'm at loss here. I can't afford an attorney to have these cases and have the current pending charges against me removed. I guess at this time I'm asking the court if you would grant me with prejudicance in regards to the things that Ms. Zalewski has done and not hold me responsible. And lower court currently is requesting, it is not a final judgment or motion at this time, which I just received, that I return my fees after 7 years that I received as the trustee, that I would have to return those funds to the trust, and also potentially be liable for the remaining funds that Ms. Zalewski stole. I guess that's all I can say.
Well, it's a very unfortunate situation, and we don't rule right here. If you've never been to the Court of Appeals, we will issue an opinion in writing, hopefully fairly soon. So, yeah, you should be getting that, as I say, with hopefully in a week or two at the most.
You know, Ms. Cruz, even though it doesn't have anything to do with the issue before us, I would hope that you and the rest of the beneficiaries follow up with the victims fund.
I agree with you. I 100%, but without them, communicating with two of the remaining beneficiaries, being myself and the second successor, Mr. Wallace had agreed to provide me with paperwork so that I may continue to do that on my own. And to this date, as of August, during the evidentiary hearing, I have not received that information from him. So I'm at loss here. Without necessary documents, I don't have anything to provide.
Well, we'll get to the next case then, but as I say, you'll be getting an opinion in the mail here with how we decided.
Thank you.
Okay.
Thank you.
Well, thank you very much for your time.
Thank you.
And this case will be submitted. I think you can turn off. Oh, yeah, there you go. All right, I think we only have one more argument. Shall we carry on or we're now at the 11 o'clock
I think
call?
we have two.
Well, one waived.
Yeah.
Yeah, on number 10. There's only one.
And then 11. It was.
Right, yeah, one person, but I
Yep.
don't see anyone here, so.
Yep.
You need a break
No,
or-
I'm
you need
good.
a break?
Yeah, no, I'm fine.
All right, we'll begin the 11 o'clock call now with item number 7. Case number 367318, Theodore Skursky versus Marilyn Lumsden. There's no oral argument on that. Mr. Flora waived it, although it was preserved, so that will be submitted on the briefs. Item number 8 was adjourned. Item number 9, I believe, is on tomorrow, correct? So that brings us to item 10. Docket number 370552, N. Ray PP. Ms. Armstrong, we learned, has waived oral argument, but we have Melissa Kelly appearing remotely. Did I pronounce your name correct?
Melissa Calais. Good afternoon or good morning, Your Honor.
All right, and I don't know, because we got late notice that Ms. Armstrong has waived. I don't know if you were aware of that or not.
Yes, Your Honor, she did reach out to me directly and inform me of that. Thank you.
Great. You look like a pilot flying a plane.
It helps me hear. These are noise canceling headphones, so it helps me focus.
Whatever you need to do, but go right ahead.
All right. Thank you. May it please the court, Melissa Calais, court appointed counsel for PP. I'll use her initials for privacy purposes. Both parties, I believe, have pretty thoroughly briefed the issues in this case, so I will be brief with my statements here. I just wanted to really kind of point out, even though I've raised 2 assignments of error that are separate assignments of error that do seem quite separate, I just want to kind of point out the interrelatedness of those issues. Because the petition did not specifically allege what relief was being sought, and because the certificates that were submitted with that petition only indicated that hospitalization was needed, there then wasn't a need for trial trial counsel to prepare for any of those issues that I raised in my second assignment of error. And of course, I can still raise those as plain error, but I think it just goes to show really how my client's due process was violated by not providing her with that proper notice of what relief was being requested. And those documents that were submitted to the court were replete with references that she was receiving her own care by her own psychiatrist. And therefore, there wasn't really a need to kind of look into the issue of whether or not it would be appropriate to have community mental health provide ongoing care for an additional potentially 6 months, thereby depriving her of her right to choose her own provider. And it's especially egregious in a situation like this, where it doesn't seem that she was actually receiving any benefit from the period of time she was in the hospital. At least the record seems to reflect that she was in the same condition at the time of trial as when she was admitted to the hospital. Whereas oftentimes we do see that even though these hearings happen quite quickly, oftentimes people have really progressed during that week or so that they're in the hospital prior to the hearing, and oftentimes are discharged just a few days later. So oftentimes what happens very shortly after the trial, when they oftentimes are released and then they're under this community mental health order, oftentimes that is the bulk of the relief that is granted in these cases. So I do think it's really significant that that was omitted here. I also wanted just to note that the prosecutor says that these deficiencies aren't something that this court should really be too concerned about, because the statute is really kind of silent on exactly what's needed other than some real basic information. However, that's really much more of a jurisdictional issue. And I just want to kind of frame it that way a little bit for the court, that I did not say that because they didn't adequately specify the relief, that therefore the court had no ability to grant any relief whatsoever because the court lacked subject matter jurisdiction to do anything. Really, what I'm saying is that we need to look at the record as a whole, see what relief was being requested, if there was some deficiency in the petition, and that they're really limited to that relief, that they can't just all of a sudden seek additional relief, particularly without making any kind of motion to amend those pleadings. So with that, those were the issues I wanted to raise, but I'm happy to answer any questions if the panel has any.
None for me.
All right. Thank you, Your Honors.
We got through without any turbulence, so that's good.
No turbulence on my end either.
Okay, thank you very much. This case will be submitted.
Thank you.
Brings us to item 11, docket number 362122, People versus Melby Sean Millerans. One party was endorsed, and that was the defendant, his lawyer, Jason Richard Febre. We see nobody here. It was scheduled for 11. Mr. Jones, do you get any word on number 11 from Mr. Egger?
Waiting this oral argument. You know that?
Okay. Yes. Okay, so that will be submitted on the briefs. And our final case of the day is item 12, docket number 370250, People versus Sarah Francis Thibodeau. And nobody preserved oral argument on that. That will be submitted on the briefs, and we are adjourned until tomorrow. Thank you, Juan. I heard a couple of peeps at first. I thought it was somebody at the table, but then a couple of people immediately tried to.